Any mention?
May it please your lordship. Hearing list, item number 20, your lordship.
Yes.
Let it be fixed after
2 weeks.
2 weeks.
Or let it go as joint request.
Jointly.
Item 20.
Yes.
And the joint request made with the parties. This is better after 2 weeks.
Yes. Highly obliged.
May it please your lordship. Your lordship, I beg to make a mention of item number 18, your lordship. I humbly pray your lordship, kindly this matter may be listed after 2 weeks, your lordship.
No objection, Lordship.
You are appealing for respondent number?
Sole respondent, your lordship.
Private respondent. State is not a party here.
No, your lordship. Only sole respondents there, private.
It is requested by the London Council for the respondent number or respond for the respondent. This is not after 2 weeks.
Lordship. Highly obliged.
Obliged, Lordship.
May I please your lordship? I beg to mention item number 17.
Yes.
Yes. The similar matter is still pending in the division bench. So I should.
Foxo.
Yes, my lordship.
3 weeks.
My lord.
This is 17. As requested by the London Council for the petition. This is not after 3 weeks. Yes.
Much obliged, lordship.
May it please lordship. Lordship, I beg to make mention of item 3.
Item 3. Yes. What happened?
Lordship, I'm seeking for
You are supposed to take instruction in this matter.
lordship.
Then what happened? You have not been able to take instruction in 3 months.
Lordship, I'm on limited instruction, your lordship.
Huh?
I'm on limited instruction, your lordship.
What limited instruction?
Lordship
Then
is
who has the full instruction?
lordship,
And who is supposed to have the full instruction?
briefing council call, lordship.
Hmm?
I'm not briefing council, your lordship. My apology, your lordship.
So who is briefing council then?
Mr. Estapa, your lordship. He is in briefman, your lordship.
No objection, your lordship.
There are so many other councils. Mr. Thapa is the only briefing council.
Lordship.
See, if certain matters are pending for taking instruction, what is the problem in that?
My apology,
It
your
takes
lordship.
3 months time for doing this. Last so many weeks you are taking time for that. Yes,
No objection since it's bereavement.
yes. For how long you need?
2 weeks, your lordship.
Just petitioner prays for the bereavement of the matter by 2 weeks. Council pending for the respondents have no objection. Prayer allowed. Please take 2 weeks. Yes.
Highly obliged, your lordship.
Lordship.
Yes.
Lordship, I beg to mention item number 21. Lordship, Mr. B. Pathak is out of station to Arunachal Pradesh and due to poor network connectivity, he could not connect.
Yes. Yes. When do you want it?
Lordship, after 2 weeks.
Please.
Let it come after 4 weeks, your lordship. The issue is pending, your lordship. That settlement,
You will have it after 3 weeks.
lordship.
Let's record it. That is the POXO matter.
Lordship, yes.
You are supporting the petitioner. Yes, just said the request made on behalf of the petitioner. This is matter after 3 weeks. Yes.
Problem.
Obliged, Lord.
Number 15 has praying for some accommodation to
Yes.
Mr. Abraham is the other side.
Yes.
No objection, your lordship.
How long?
2 weeks, 3 weeks.
3 weeks. Yes, sir. The request made on behalf of petitioner or made yes on behalf of the list of 2 weeks. Yes.
Highly obliged.
Please, your lordship. Lordship, I beg to make a mention of item 9.
Yes.
Lordship, I'm praying for 2 weeks' time, lordship.
So Yes, the petition, please show the 2 weeks. Yes,
Obliged.
Lordship, a similar prayer for item 14.
with the other side reporting.
Well, I am for the state. This for the private respondent.
For the private respondent. When?
Lordship, 2 weeks.
Same order. Yes.
Highly obliged.
Obliged.
Lordship, I beg to mention item number 12 and 13 for 3 weeks, Your Lordship.
No objection, Your Lordship.
Same. Yes.
Your Lordship, I beg to mention item number 6. Your Lordship,
Item number?
item number 6, Your Lordship. Your Lordship, I humbly pray to take up this matter after 2 weeks, Your Lordship.
Yes.
No objection, Lord.
This for what? What is this matter about?
This is service matter, Lordship.
The disciplinary proceeding, Your Lordship.
Disciplinary proceeding.
Yes, Your Lordship.
This person has been dismissed from service.
Yes, Your Lord.
Suspended, not dismissed yet. Pending for
The
departmental proceeding.
challenge here is to the order of suspension.
Yes, Lord.
Yes, Your Lordship. Still under
You are
suspension.
appearing for?
Respondent number 3 to 4.
Who is
3 and
3?
4. It's SD, Your Lordship.
Yes.
He is working in which department? Petitioner is working in which department?
Bakmara Municipal Board, Lordship.
But you are appearing for the municipal.
Yeah.
Yes.
Yes, Your Lordship.
You are for the state.
Yes.
And for the state, she is appearing for the municipal board.
Municipal Bakmara.
Yes. And what role the state has here?
State initially, because that time the state has filed an affidavit. Municipal board was not properly functioning at that relevant point of time.
It was under some administrator.
Yes.
Okay. How long you?
2 weeks, Your Lordship.
Yes, the request me don't give the respondent number.
3 to 4.
Sir, place this matter after 2 weeks. Yes.
Obliged.
Highly obliged, Your Lordship.
Lordship, I beg to mention number item 10,
Yes.
2 weeks, Your Lordship.
Why? 2 weeks?
Not yet ready. And item number 11 also is a connected case.
So both the matters. You are appearing for. You are making mention on behalf of the petitioner.
Petitioner.
Yes. We have no objection. This also same order. Yes.
Lordship, I beg to mention item number 19 on behalf of Madam Yangi.
Lordship, I'm appearing for the appellant in this matter.
Yes.
She's on sanction leave, Lordship. If this matter may kindly
Who?
come. Madam Yangi.
Yes, Dr. Agarwal.
Lordship, no objection.
Yes. Yes. This also. Mr. Hind. Another GA appearing for the state respondents. Place for grant of sign sometime on the ground of substance of MSP Yangi, non additional AG, who is appearing for the state in this matter. Dr. P. Agarwal, learned counsel, appearing for the learned legal aid counsel, appearing for the petitioner has no objection. Prayer allowed, list up 2 weeks. 2 weeks.
Lordship, if it could be 3 weeks, Lordship.
List up for 3 weeks.
Highly
Obliged.
obliged.
May it please, Lordship. Lordship, I beg to mention this item number 4 and 5. They are connected matters, Lordship. Lordship, the states have filed their affidavit in terms of this order dated 12/7/2024, Lordship.
Yes.
We have just received a copy this morning, so we require some time
What is
to
the matter
process
about?
it, Lordship.
Lord, this is that teacher matter. Lord.
The teacher matter where the
Teacher is claiming
teacher
that
was
he
removed.
was appointed. Well, the claim of the teacher is that he was appointed.
Also where the teacher was removed from his service and another teacher was appointed who is not unqualified.
You say that the new teacher who has been appointed does not have the requisite qualification.
Lordship.
That is your case.
That is the matter, Lordship. It was heard at some length, Lordship. this matter.
Your removal is also on account of not having
Not having the required qualification. So Lordship, this matter can come after 2 weeks. We need some time to peruse the affidavit and file a rejoinder if necessary, Lordship.
Okay. It is submitted by the learned counsel for the petitioner that an affidavit in terms of order dated
12/07/2024, Lordship.
of the date has been filed with the state respondent only yesterday.
This, in fact, this morning.
Only this morning. Only today. Only today. And the petitioner did not get a chance to go through the same. The learned counsel therefore prays that the petitioner may be allowed some time to go through this same. And petitioner may allow some time to enable him to go through the same. And to next course of step in the matter. Prayer allowed, list after 2 weeks.
Deeply obliged.
Your Lordship, I beg to mention item number 2.
Lordship, I have no objection, Lordship. No objection, Lordship.
What happened?
Senior
Let
counsel
us
is
hear.
Conducting counsel.
Prayer to object or not. Yes.
The conducting counsel is not well, Your Lordship.
Since
Mr. Kinta.
we were informed that the
He is in hospital.
He was.
What happened to him?
He had some.
Any information? No information. Yes. What happened to Mr. Kinta?
He was hospitalized last week, but he's back home now. And
what happened? What had happened to him?
Something with the blood pressure, Your Lordship.
Now he is at home.
Yes, he's in recovery, Your Lordship.
So we'll just. Is it a joint prayer?
Lordship, they're making the prayer, Lordship.
I pray for 3 weeks' time, Your Lordship.
Yes, it is reported that the learned senior counsel lecturing on behalf of respondent number
1, 3, and 6.
1, 3, and 6
1, 2, 3, and 6
is unwell. And prayer for adjournment has been made on account of the illness. The prayer for adjournment has been made on behalf of the said respondent on account of the illness of the learned senior counsel. The learned counsel or the petitioner has no objection. Prayer allowed, list after?
After 3 weeks, Your Lordship.
This is all right with you?
No issues. Deeply obliged.
Daily cause list, item number 1.
Yes, my lord, the respondents 2 and 3 have been delivered the notice on 30th September.
Have you filed an affidavit?
Not yet. I just searched it today. I'll file an affidavit to that effect.
Your Lordship, I'm for the respondent number 4.
The respondent number?
Number 4, Lordship.
Come, that's a respondent is this. You enter appearance on behalf of the respondent number 4. So 2 and 3, according to you, have.
Yes, I have got yesterday only.
Who else are remaining?
The addressee has been delivered on 30th March.
Then who else have been
Hitesh Brahma and Jagat Brahma. Those are the persons.
Their respondent number?
2 and 3.
Who are this?
5, 6, 7, and 8.
Five,
No,
six,
no,
seven,
they
eight.
have been, I have filed an application for withdrawing them as parties, as,
Yes, that is who's left.
no one left now. Those,
On the last occasion, your submissions were not taken on record.
Was there any order passed?
No, there was no order, sir. So because
I
there
had
was
filed an application.
Yes.
Yes, yes.
Yes,
Then it
what
was
was the
not
order
taken.
was passed?
I'm not aware of the order actually.
Your application, you are not aware, then who will be aware then?
Actually, I had entrusted my junior, I had gone outside, that's why. That is why. Order was not passed because my juniors had not been given wakalat
Should have
number.
been pointed out. Any objection to this application? Anyway, just say hard, Mr. Hard, Mr. No, you just hard. Petitioner. Hard the petitioner appearing in person. This is Miss case number 102. Okay. So you say this is an application for striking of the respondent number 5, 6, 7, and 8 from the array of parties in criminal division number
14.
14 of 2023. See, Mr. Bora, your petition doesn't mention about the criminal division petition. Oh, it's only on the top. Acha, anyway. Okay.
It's on the top.
For this is also. Okay. So on the ground that the presence of deceased respondents are not required for adjudication of the matter, and the petitioner also has not made any prayer. Petitioner also has not claimed any relief against them. Without seeking relief, you just say petitioner also has not made any prayer against them. Stop. The learned counsel appearing for the respondent number, you are 1, and respondent number 4 have no objection to the prayer made in this application. Accordingly, this application stands alone. The respondent numbers, the names of respondent number 5, 6, 7, and 8 stand deleted from the area of parties in criminal division petition number 14 of 2024, 14 of 2023. Stop. The petitioner shall take steps for correcting for correction of the postage of the revision petition. Stop. Application list stands. Application disposal. The application is disposal. Acha, in this main come to criminal petition. You say the petitioner has submitted that. Oh, just say Mr. Majao has entered appearance on behalf of the respondent number 4. What is your prayer?
Your Lordship, respondent number 4 basically, Your Lordship, he has sold his vehicle to
No, see, like at this stage, we are not going to merit such a case right now.
He dismissed because Your Lordship, we've been.
Do you have a prayer for filing any objection or no? You do not have.
No, Your Lordship.
He says has entered appearance. Mr. Give a stop. The petitioner submits that the one number 2 and 3 have already been served. However, the office note indicates, office note dated 16/10/2024 indicates that the said respondent indicates that the service report of upon the said respondents are still awaited. The petitioner shall obtain the status of service of notice upon the respondent number 2 and 3 and file an affidavit of service to that effect. List of activities. You file an affidavit,
Yes, yes.
Supplementary causes, item number 1.
May it please your Lordship. Lordship, I pray this matter may come at the end of the board, your Lordship.
Yes.
As the learned SGI is currently on legs, your Lordship.
You have filed a
I filed the application. I filed an application.
You have filed your application.
Yes, my lord.
No.
Filed today morning, my lord.
Let them take instruction.
My lord, I believe he's on legs, my lord. Let it come after at the end of the board.
No, no. See, this matter, once it is served, whether
My
they will be needing to take instruction or not, that is the main thing.
My lord.
Let them take instruction and we'll take it up for disposal on Monday.
My lord.
Okay. Instead of waiting for him, just say in the miscase, this is a miscase number. Miscase 1. Isn't it?
1.
Yes.
It's 1.
Miscase 1 of 2024. This is an application for bail, praying for bail.
My lord, suspension of sentence and interim bail, my lord. Because, my lord, until unless.
For suspension of sentence, you have already an application.
My lord, I cannot directly make a prayer for bail once I am convicted, my lord. Sentence for the time being will be suspended only for the interim period because, my lord.
Do you want to say,
my lord,
do you want to say,
lordship,
that in this urgent situation,
my lord,
you cannot make a prayer for bail?
I can make a prayer for bail,
Yes, why
but my
not?
lord, only after the sentence is suspended, my lord, then only the consequence will be bail. Because here a man has already been convicted and he has been sentenced by the BSF court, my lord.
So, say supposing,
My lord.
until and unless the sentence is stayed,
My lord. Not state, my lord. There is a difference between, my lord.
the sentence is stayed,
My lord.
is kept in abeyance.
Abeyance.
A person, a convict cannot be released on bail, you want to say?
My lord, that is what I mean.
Even
That
for
is,
temporary period, for
My lord.
attending some exigencies.
my lord, because that particular period, my lord, later on, my lord, if I don't come out successful in this particular case, my lord, will be added to the sentence, my lord. So until unless for that, for the
Because
brief period,
you remain out of, this is common, this is simple thing, this is,
my lord,
you see, he cannot say that cannot be released, he can be released. Say supposing in case of exigency.
lordship. On bail, my lord, yes, yes.
Somebody in custody
My lord,
because of his conviction. And while he is in custody,
my lord.
his parent, one of his parents dies.
Right, yes, yes. For the brief period of time, my lord, he can be released on bail. But the bail will be the consequence of only.
Depending on urgency of the situation, is it?
Yes, my lord. My lord, my prayer is for interim bail, my lord. Lordship may consider that, my lord.
That is what exactly.
The technical aspect, my
just
lord.
for the purpose of recording.
Yes, yes.
What exactly this application is about,
my lord.
That is why the court is asking.
It is for temporary bail, my lord.
Yes. Yes. Just say this is number 1. This is an application for a release of the petitioner on temporary bail. To enable him to visit his ailing
father, my lord.
Father, who is stated to be in very critical condition. Step. The counsel for the respondent shall obtain necessary instruction in the matter. This is the matter on give Monday's date.
But it can be taken up tomorrow, my lord. The
If
problem
it
is, my
not
lord.
done today, then again will be problem. See, why you are trying to push it so hard? Just
Well,
wait.
I've
You
served
see,
a copy in the morning, my lord. Well, my anxiety is, my lord, because the condition of the, well, I just got a call sometime back also. When his condition
do
is
not get
very
so
bad.
emotional. You see, unnecessary things will be delayed. And if they say they fail that, if you give them one time, Monday at least they will have sufficient
He'll
time.
receive
to
verbal
decide.
instructions probably, my lord.
That is what. So at least they do not get any opportunity to ask for time on Monday. So that is what.
My lord.
Keep it tomorrow, then again it may happen like this. See, they may say that they did not get instruction. And it is one day, then they ask for time, then you have to, at least here we'll be giving them 2-3 days. So you have your instruction, we have keeping having it on Monday.
My lord.
Yes, and then the main case also. Just write, list it on. So this is Dr. Mojika, please have your complete instruction so that we can do this thing. And just go to the application and check the laws.
Right. Obliged.
Daily causeless hearing item number 7.
Yes.
May it please your Lordship. Lordship, the petitioner has been appointed on compassionate ground on the 16th June 1994. Can you come to page 11, Lordship?
What is the matter about? What is what is your prayer in the
The matter is like this, your Lordship. She was appointed in 94.
Matter is regarding seniority, my lord. If I may
It's
interject.
not exactly seniority, your Lordship. I'm aggrieved by one condition, that is, she was appointed in 94, Lordship, and the condition is such that she has to be date of approval is in 2016, Lordship, after a gap of 22 years. So, Lordship, that is the grievances.
when did you approach this court?
Exactly, my lord. 2018.
Wait, kindly, why you let us apologize. Please take your seat.
Lordship, I approached this court in 2018.
So, so you also did not bother to approach this court.
Lordship,
If
I
they
have
had not taken a decision in 2016, you would not have approached this court.
no, Lordship, it's like this. I have filed a representation in the past, Lordship, but the same has not been considered.
Filing representation and waiting for the decision for more than 2 decades is something very unusual. So that will definitely not cover up the delay which you have committed. Anyway, let us see your what your case is about.
Can you turn to page 11, Lordship? This is the appointment letter. This is English translation.
Page 11.
Yes, annexure 1, Lordship. Page 11. Lordship, may I read this? Sure.
Yes, please.
Dated 16 June 94.
Yes.
Subject to discharge without notice and assigning any reason thereof, Srimati Petitioner Basayumait, this is the petitioner, Lordship, daughter of so-and-so, who died in harness, is hereby appointed to the post of LDA on compassionate ground in the scale pay of such and such, plus other allowances, as admissible in OO, the divisional forest officer, East Kazil District Law, with effect from the date of joining Vice Srimati so-and-so, promoted to the post of LDA. Lordship, she has been appointed on 16 June 1994. Lordship, now I will take your Lordship.
Now, this says the appointment is period temporary and subject to approval and good police report.
Lordship.
Isn't it? Yes.
Lordship, I will take your Lordship to page 13, Lordship, annexure 2. Annexure 2, Lordship. Here, Lordship, I am aggrieved by this condition which is stipulated here, Lordship.
Annexure?
Annexure 2, Lordship.
Sir, yes, Lord, sit down. Why? What is the problem? Any urgency? Yes. What do you want to say?
Lordship, I may be allowed to complete this short.
No, there is okay. Then, see, like if, until unless there is a cause for it, do not interpret. Do not interfere. I see.
My lord,
if you intervene,
only
then
thing is
it's
that, my lord, my senior had this morning informed me that, my lord, they want to make a new representation. So, my lord, if
That also, I will come to that, Lordship. I will come to that.
otherwise, my lord, let the matter come up next week.
Let us just
No.
come get the matter.
I will come to that, Lordship.
Yes. Here, then annexure to page 13. Yes.
Yes, Lordship. Here, Lordship, after a gap of 22 years, Lordship.
Yes.
May I read, Lordship?
Yes.
To the additional principal chief conservation of forest administration, Meghalaya, Shillong, subject appointment on compassionate ground in respect of Shrimati Decrease Pasahima, Doctor of so-and-so. Reference such as such. Sir, inviting a reference to the proposal cited above, I am directed to inform you that government and personnel ARB department has agreed to the personal appointment on compassionate ground in respect of Shrimati Decrease Pasahima, Doctor of so-and-so. Ex-LDA as LDA on condition, this one, that the date of effect of such appointment should be from the date of approval of personal AR and B department, that is 21st/3/2016. I'm agree with this, Lordship. After long gap, this condition, when she was appointed 94, Lordship, 22 years back, how can it be that how can it be that on condition that the date of effect of such appointment should be on this date, Lordship?
Yes.
Lordship, now I'm not agree by any other. I'm agree by this, Lordship. See, she is not getting any benefit, Lordship. And Lordship, I think in all fairness, I may be allowed to approach the authority once again by a fresh representation, and then let the authority consider, Lordship.
So then, in such a case, we will close this petition.
Yes, Lordship.
Liberty to approve this.
Yes, Lordship. With a certain condition that the representation should be disposed of within a certain.
Just tell us why approval from a subsequent date? Under what law? See the first appointment letter.
But that appointment letter itself is not tenable, my lord.
Why?
My lord, the authority which is given for the appointment, my lord, is not competent authority.
Now this is an appointment issued by you, isn't it? And now you are challenging the validity of it.
My lord, this, yes.
How can it be?
Exactly, my lord.
How can it be?
It is made by one of the officers.
Did you withdraw it? See, that is your document. When you face difficulty, you come to the challenge and you challenge your own document. Why it is wrong? What is wrong in it?
Yes, my lord, because there is a certain, my lord, compassionate appointment, there is a certain procedure which has to be followed.
Yes, and what are the procedures which has not been followed?
My lord. First, my lord,
just tell us what are the procedures which has not been
most important thing, my lord, is there has to be a proper application submitted by the candidate before the proper authority. Now, if it is submitted to the office is to forward it to the government, my lord.
Yes. So
there is a certain.
It means the approval will be dependent on the submission of the proper document.
Yes.
Is it? So before you decided to approve by this 2016 letter, what were the documents submitted by you? On what basis you have given this approval? Or you will say that this is also not valid now?
No, my lord, this approval, of course.
This approval is
subsequently
valid.
the government decided to consider.
If approval is with effect from 21/3/2016, no document, proper document is required to be submitted. Now, but then if its approval is to be given effect from 16 June 1994, submission of proper document is required. Is it your argument?
No, no, that is not my argument.
Then tell us what are the documents which are submitted by the petitioner prior to your decision of regularizing petitioner from 21/3/2016. Give us.
Well, that instructions I'll have to get from the.
No. See, you are arguing a case. This is a matter of argument. You have raised a pertinent question. You said that initial order of appointment is not valid because of non-submission of certain documents as per the requirement of the scheme.
Yes.
But then it is your decision to approve the same appointment with effect from 21/3/2016. Now tell us what were these deficiencies which are corrected in the meanwhile. There is no question of taking
because today my senior was telling that.
No, take down. This is something we do not know. Not at all.
Well, today my senior had. My lord,
Mr. You are expected to make acceptable argument.
My lord,
do not just stand up and defend government when you yourself find the decision is not correct.
No, that is not the case, my lord.
We would have accepted your argument had there been a denial on your part to give approval. You have given approval, but the only thing is that You want that this service be approved from a subsequent date. Why?
My lord, there are certain rules, regulations, my lord. So today, my lord, let the matter come up next week.
We'll record your submission and we will say that you are not in a
No,
position
it will
to
require
show.
little, some hearing, my lord. Let it come up next week.
No, you see, we are inclined. We have seen since the petitioner is very fair that they want.
So, my lord, if that is so, it will.
But then we will make some observation. We will close this case, and the petitioner will have a liberty to approve.
My lord, the only thing is that, my lord, if as far as because she is questioning, ultimately she is questioning or raising issue regarding the seniority, my lord.
No,
So
that is not the.
yes, my lord. Ultimately, the seniority of the other people will also
See,
are
so
also
far
going
as
to be
the
affected.
submission of the landed council is concerned, he has not made any argument on that seniority. Only he said that he is aggrieved by the decision of the government to regularize the service from a subsequent date.
Yes, Lordship.
That is what his submission is.
Lordship, can
And we find that is a valid, very valid argument.
My lord will kindly see. My lord will kindly see in the prayer, my lord, for the purpose
We are
of
not
seniority.
giving, we are not granting. This prayer has not been praised.
For the purpose of seniority.
Yes, he has not been praised.
So if it is only a question of representation, my lord, he can file a
See,
representation.
question of
my lord.
representation, this otherwise for submission of representation, the petitioner doesn't need any permission of this court.
No, Lordship.
Now, only thing is the pendency of this matter may be a problem. But then, if you are justifying your action of approving this regularization from subsequent date, then give us the reason. It goes basically your own argument is negated by the very decision.
My lord, I will need some instructions.
You see, your very argument that 1994 appointment order suffers because of non-submission of certain relevant documents. But then on the same situation, you approve this appointment from a subsequent date. Your own argument is contradictory.
My lord, at least on that aspect, I will require some instructions, my lord, that on what
If
basis.
not in any instruction, probably you advise your department to take action. Otherwise, you do not have it. You can tell the court that there is a prime. Tell your department that there is a primacy view of it.
My lord. So, my lord, at least will
And
grant
if department
me.
is ready to correct it, then this.
At least will grant me some
you
time.
convey. Mr. Noklau, let us wait. Let him convey the department the view of this court. In the meanwhile, if they agree to, you see, like modify that order, regularizing your service from the day on which you joined, that will serve your purpose.
That was so.
But it has made it clear to him.
But my lord, indirectly, it is also going to affect the seniority of several other
Just
candidates.
Take them. Hard landed counsel for the parties at some time. The petitioner is aggrieved. By a communication made by memo number C annexure 2, page 13. Memo number so and so dated date, whereby the respondent, state respondents have taken a decision to regularize her service with effect from 21/3/2016. Whereas the petitioner was appointed by order dated 16 June. By memo number, you just see annexure 1. Okay.
Annexure 1.
11. By memo number dated 16 June 1994. What you said? Just this line, the beginning of this line. Okay, just sit down. Just okay, sit down. That's it. The main contention, the learned counsel for the petitioner. Sorry, the learned counsel for the petitioner contended that since the petitioner was appointed on compassionate ground by order dated 16 June 1994, the regularization of her service with effect from 21/2016 is wholly unjustified and arbitrary. And in defiance of any logical explanation. Stop. It is a submission of the Learned Counsel that once the petitioner has been appointed on compassionate ground on a certain date, the approval to such appointment cannot be made effective from the subsequent date, which is more than 2 decades of her actual date of appointment. Stop. Your paragraph. Per contra, Mr. K.P. Bhattacharya, learned GA, appearing for the state, submits that the initial appointment dated 16th June 1994 suffers from many deficiencies, inasmuch as the said appointment was recorded without submission of requisite documents and papers by the petitioner in terms of the requirement of the related scheme.
My lord, that OM is dated 11 December 1984.
Then you tell us then what is the specific things which have not been done.
My lord, firstly, my lord,
anyway, it's okay. What was the thing? In terms of the relevant scheme, isn't it? Yes, stop. Same as was accorded without submission of the relevant documents and papers of the requirement of the related scheme. Stop. It is a submission that since the original appointment was not in accordance with strict terms of the scheme for compassionate appointment, the order the communication dated 22nd March 2016, by which the petitioner's service was regularized with effect from 21/3/2016, does not suffer from any illegality or arbitrariness. Give a paragraph. On the query of the court as to what is the deficiency, what is the specific deficiency in the initial appointment of the petitioner, the landed GA is unable to point out.
My lord, it is there in the scheme itself.
Please kindly, just we say any specific. What did you want to say?
My lord, this is, if I may give my lord a copy, my lord. It is there in the OM.
Is it a part of this thing?
No, my lord, this is not a part of the affidavit.
What do
but
you
this is
say?
a part of
What
the
has not
record.
been submitted? You just say. What are the things which the petitioner did not submit?
My lord, this is the scheme of OM dated 11
We
December
understand.
1980.
We understand that.
Firstly,
As
my
per the
lord,
scheme,
yes,
what was the requirement and which has not been followed by the petitioner?
yes, my lord. If I am allowed to read, my lord.
What has not been done, submitted?
Yes, my lord. Application in the standard form in the annexure for such employment should be made to the Chief Secretary, to the Government of Meghalaya through the head of the department office in which the government servant was last
So
employed.
that was not done.
My lord, this
Okay,
is one.
the first one is that there was no submission of application to the Chief Secretary.
The head
That
of
is
the
the first
department.
point. The second point?
Second point, my lord, the appointments can be made only against such post for which direct recruitment has been provided in the relevant recruitment rules.
So you want to say that LDC's position is not a direct, it's not a post for direct recruitment. Mr. Bhattacharya, please be careful that your submission should not invite more trouble for the state. It's up to you. If you want to make some submission on assumption, you can do it. We'll record it. There is no problem in it.
So, my lord,
see. Now, are you sure that those things have not been done? We'll record it.
my lord, most important that application, my lord, that application was never made.
Now, just have you taken that ground in your affidavit of opposition?
Yes, sir.
That has not been submitted, and that is the reason.
Yes, sir.
Now, do you want to say that this deficiency was covered up prior to your approval, grant of approval?
Well, that stand is not taken by us.
What we say? Stop. The Learned G submitted that the petitioner had not submitted any application in standard form as prescribed under this scheme of compassionate appointment. And the second thing is that this LDC post is not direct recruitment. That is what you say.
No, my lord, direct recruitment is also there.
That is the only one.
Direct recruitment is also there, my lord. Direct as well as promotion.
Okay. Now, is it your case that after that, she has submitted that before you approved the decision? No.
That instructions, of course, I'll have to take from the department.
You see, we do not know why you are.
But my lord, my affidavit, we have raised a lot of valid points.
We are not giving it this thing.
Merit.
No, if you want it, we can do it then.
No, my lord.
No, there's no problem.
I'll take instructions from the department.
You see, you have caused enough disruption. You see the while passing order.
My apologies.
Please. Yes. Addressing it to the Chief Secretary of the state. However, he is not in a position to clarify as to whether the petitioner had covered up the deficiency prior to the regularization of service with effect from 21/2016 by the state respondents. Give a paragraph. Prima facie, it appears that if non-submission of requisite documents was the reason for not according approval of the petitioner service with effect from the date of issue of appointment order in her favor. Come on. The state respondent could not have regularized her service without fulfillment of without without fulfillment of the deficiencies as pointed out by the learned GA. In such a situation, the state respondent should not have gone ahead with the decision to approve the service of the petitioner. Stop. Since the state has taken a decision to approve the service of the petitioner, it is assumed that the deficiencies which the Learned State Council has pointed out stood corrected and covered up. However, there is nothing on record as to why this approval has been given. There is nothing on record to justify as to why the approval has been given with effect from 21/2016 instead of the date of issuance of the appointment order. Give a paragraph. Is at this stage, Mr. Notlaw, Learned Counsel for the petitioner submits that the petitioner may be allowed to approach the respondent authority by filing a fresh representation to the respondent number
2, Lordship. 2, 3, and 4.
to the respondent number 2, 3, and 4.
The appointing authority. The appointing authority.
Let the representation be. Anyway, it is up to petitioner.
Yes, sir.
But here the respondent number 1 is the secretary, my lord.
One is the secretary of the government of Meghalaya.
Forest member.
Now, according to you, this representation should go to whom? Anyway, you do one thing. You just say, what is it at this stage? Fresh. Acha. Yes. Respondent authority. Acha, biling afresh. To the state respondents.
For consideration.
For redressal of our grievance. To which the learned GA has no objection. We'll dispose of this application then.
Yes.
There is no question.
It's okay.
Okay. You stop in view of the stop paragraph. We have recorded that you have no objection to this prayer for filing of these things. Representation.
Presentation is okay.
Yes. So you are not giving any objection to that.
As far as representation is concerned.
At this stage, because see the question of asking this doesn't matter, but since it has come at a stage when this writ petition has remained pending for certain period of time, so that is why it's important to record that. Okay, then just say in view of the above, this writ petition is disposed.
Lordship, with a direction for 3 months' time to be disposed of my fresh.
We'll do it. Just wait.
Sorry.
With come on, writ petition is disposed of with liberty to the petitioner to approach the respondent authority once again for redressal of her grievance. Stop. In the event the petitioner files, in the event the petitioner files any such application, any such representation, the respondent, who will the person who will decide it? Then in such a case we will be needing specific things. Who shall take a decision?
Otherwise, my lord.
Appointing authority, Lordship. The appointing authority, Lordship.
Your appointing authority and your approving authority may not be seen. Anyway, we'll do direct the response number 1. I think that will be proper, Mr.
Okay, Lordship.
What was it in the event? Come on, the respondents, the respondents, come on. But particularly the respondent number 1 shall dispose of the said application within a period of 1 month. In the light of the observational discussions made here in above. Then next paragraph, the petition stands disposed of. No order to cost. No order is to cost.
But only one small clarification, my lord, if my lord allows. My lord, because ultimately, no doubt, but ultimately the order will have to come from the Personal and Administrative Reforms Department. Of course, they are not a, I'm not sure if they are a party here.
See, if any representation is filed to particular respondent, you will take steps. Okay. You can forward it to the respondent.
Because government ultimately the main order will come.
Period of what we said, make it 2 months.
Well,
so in such a case, what you say is if it is reflected.
Well, can it be 3 months?
It's okay,
just because the petitioner wants it. Okay, make it 3 months. No problem. You cannot say no because initially you said it's 3 months. The court thought it should be shorter than that.
Anyway,
there may be a little bit correction here there if we find it. This is code dictation, sometimes some mistakes are there. So yes.
Item number 8.
Yes, Mr. Majumdar.
For a matter of termination of service.
Yes.
On earlier occasion, there was a attempt to reconcile whether they could have converted the dismissal to a compulsory retirement to shorten the litigation and all. Apparently, on the last occasion, there was some order passed by the Honorable the Chief Justice then, my lord, and that order lordship would see.
Those matters were transferred to the court of the CJ at that point of time, I think.
My lord, yes.
And what is the order?
2nd of May 2024, my lord. There was one, and another was the 30th of May, my lord. Thereafter, the matter came up before lordships, where submission was made that it could not be done.
Okay.
So now, my lord, the matter has to be heard on merit. Now, situation in this matter is the person, my lord, he was enrolled in the Assam Rifle in the year 1974. Then he got 2 promotions. He was enrolled as a rifleman GD, and then, my lord, he got 2 of his promotions to the next higher ranks in 1978 and 1982. Thereafter, my lord, he was given leave in the year 1993. From the 1st of October 1993 to 20th of October 1993, my lord, he was given leave.
Just before you come
My lord.
to detailed submission, what is the matter about this? Your dismissal is on account of?
My lord, I remained absent without leave
Unauthorized.
Unauthorized.
For how long?
My lord, I had reported back at a particular point of time. They required me to go back and get the court papers, which said that
What
I
is
should
their
be
allegation? As per them,
As
what is the absence? What is the period of absence?
my lord, I remained absent from 1993. They first dismissed me on 29/7/2003. I say first because there were 3 orders of dismissal, all with retrospective effect.
3 orders of dismissal.
3 orders of dismissal and all with retrospective effect. My lord, settled position in law, the termination could not have been retrospective. Now, I am not challenging the actual termination as such, my lord, because from the history of litigation, it will come out. The petitioner, instead of, as of now, he is of the age of retirement, but even at that point of time, he was more interested in getting some sort of a pension or a compassionate allowance, because the unauthorized leave was
you do not want your
service back. All that was required to be
you
done by
want
them.
something to sustain yourself.
And that, my lord, perhaps is.
And that Dr. Mojika is not agreeing. The respondent is not agreeing.
And
We
the
not say Dr. Mojika will say respondent.
The respondents, my lord, when they rejected that prayer, they had done it only on the basis of CCS pension rules, Rule 24. They did not make a reference to Rule 41 of the CCS pension rules. Now, settled law by this Honorable Supreme Court is when a man is terminated with 19 years of service, even if you take it from 1993, retrospective termination, if you take it, even then he has got 19 years of service. If you take it from the first 2003, which they say is a wrong order, then I would have around 23 years of service. If we take it from 2011, when I was last terminated from service, I would have nearly 40 years of service, 36 plus years of service.
So they should have given you something, isn't it?
That is not a
Yes, Dr. Mojika, is it not that it is appears to be quite legitimate if he is not asking back his service and he wants something to sustain him?
My lord, Lordship kindly sees the facts of the case, my lord. How he tried to cheat the department.
That would come in if the orders reflect so.
My lord,
he would not be the case.
He went on leave. My lord, I'll just give few dates.
Of course, we have not heard Mr. Majumdar on merit.
If he's coming on facts,
we are just on the basis of the initial things.
Then Mr. Majumdar will be free to he can submit his. My lord, he took leave for 20 days, my lord, from 1/10/93 till 20/10/1993, my lord. 93, my lord. We are in 2024 now.
Yes, leave from 1/10/93.
1/10/93 to 20/10/93.
Yes.
So he was required to join back
20 days.
20 days, my lord.
Yes.
What happens, my lord? If somebody does not join in time, my lord, because they are the members of armed forces, so there is a procedure that Assam Rifle issues an apprehension roll to the SP office, to the police of.
There is no provisions of extension. Like
If he applies for extension, my lord, then depending on the facts and circumstances, it can be extended, my lord.
So it can be.
It can be extended, but in this case, there was no request for extension also.
Yes.
Apprehension rule said, my lord, that he left his house somewhere in UPI, my lord.
Now, he failed to join on 21st.
My lord.
Then what happened?
Then we followed the procedure, my lord. Later on, what transpired, my lord?
There was no application by him for extension of the leave.
There were no extension. Now, my lord, his wife, what he does, my lord, through his some contacts, he sends a letter to Assam Rifle that he has been kidnapped by NSCN, my lord.
He was posted where? He was in Nagaland.
Mokokchung, I was at Dimapur. I was to travel via Dimapur.
He was in Nagaland.
I was to travel via Dimapur.
So, my lord, and a ransom note for payment has been a false, forged ransom note from NSCN sent to Assam Rifle that my husband has been kidnapped by militants, and they have given the
Kidnapped when? On which date he was kidnapped, and which date she informed it?
My lord, the fact is that this was completely false, my lord.
Anyway,
he was never kidnapped, my lord. Actually, what happened? He was caught with drugs, my lord, by Manipur police.
And he was arrested then.
He was arrested by police there. Now, in these facts and circumstances of the case, my lord, how we try to cheat the department, my lord, he creates false letters, my lord, false documents.
These are all admitted positions. No.
But this is on record, my lord.
He was just giving dates. I thought he was giving dates. He's going on merits.
So you were never caught with drugs and all.
What happened is this, madam. While I was returning back, I was traveling in an auto which was intercepted by police, and I was taken into custody. I got my bail. I reported back. When I was coming back to report, I'm sorry, madam. When I was coming to join my duties, I was first abducted. I escaped. I came to the auto where I was arrested.
What are the dates on which date?
My lord, I was arrested on.
No, from which day to which day you were in custody?
I was in custody till 16/12/1995. From 21st,
where you arrested?
17/10/1993. I was arrested
before expiry of your leave.
Yes, I was coming back to join my duties. On 21st, I was
coming
required
back
to from my hometown Balia, Uttar Pradesh.
How long it takes? What is the journey time there?
At that point of time, 1993, my lordship will take the train journey part and the to reach Dimapur, and then I reach my place of location, by which they admit I have to go by a convoy, which then run from by the Assam Rifles. We did not have public transport to my place of duty. I had to go on a convoy. Convoy used to run 2 or 3 days a week. So I started on 17th. I was abducted. I was arrested by the police. I got my bail on 16/12/1995. I reported back to them on 12/8/1996. I reported back.
Now, when you were arrested, your department was not informed.
No. Their department was informed. Department was informed by my wife while I was under arrest. It was on the with the help of the department that I got my bail.
You were a member of armed force.
Yes.
So if you are taken into custody,
yes,
it is normally the department is informed, isn't it?
Yes.
So there
So
was
therefore,
no
the department was informed. My wife also informed that this was what has gone on. My husband is in jail. I cannot go for the bail part. Please help me out. It was on efforts of the department that I got my bail. That is also on record. That is what my wife's letter says. That is what their documents say, that my wife informed that my husband is in jail. Please help him out. They conducted an inquiry. They knew I was under arrest. When I went back to join, I was turned down, saying that go back and get your innocent papers. Papers declaring yourself to be innocent. That was in the year 1996. I was turned back. I could not follow up the case which took place in Assam.
Who was supposed to give that innocence?
My lord, that was the court proceedings had to come to an end, was what they were trying to say. An acquittal, an order of acquittal is what they wanted.
There is nothing called innocence.
No, their letter says that you should get documents of your innocence.
Anyway, that is probably their ignorance, the person who is...
Otherwise, it is an acquittal, which I had to come back with.
That means that your acquittal order, isn't it?
They wanted an acquittal order. I could not get it till the time. They first dismissed me on 29/7/2003. Now, all these which have been brought on record now, which have been now brought on in the affidavit, or which are now being placed before the court, were not part of the orders, or not a matter of consideration when my terminations took place. The termination orders, Lordship will see. Because introduction of these factors, that these were factors when my termination
All these facts are stated in details in your writ petition.
In my writ petition, yes. Yes, I have stated them. Lordship will find at page 4, para 3 onwards.
It's all right. It's all right.
It's there, madam. Now, Lordship would find at page, yes, 17 is the typed copy, 18 is the original. Page 18, Lordship will find is given by 30 Assam Rifles. To me, submission of documents, you are hereby directed to submit the court documents which have proved by the court regarding your innocence from further action, please. Page 18, Lordship has. So I was to come back with my acquittal, if I understand that. Then Lordship will find at page 19.
They ask for court documents.
They ask for court documents which prove my
it is not nothing that you submit a paper of innocence. It is not that.
But they say by court regarding your innocence for further action.
That is all right. There is nothing wrong in it.
Page 19 is where they refer to the letter written by my wife and they want an enquiry to be conducted. Now she finds an application dated so and so received from Chandrabi Devi of your unit is enclosed herewith. For your further action, you are requested to investigate the matter and offer your comments at the earliest with intimation to the addressee. Now, this happens when my wife writes to them that my husband was kidnapped, he was under jail and we are not having anything to eat and it is being very difficult, and so please give us whatever we need to eat. This was the letter. Then Lordship would find at page 20, the first termination order. Lordship would see where is
Enquiry was ordered on 3rd September 98.
98. Now, in the affidavit in opposition, they have given few comments given by the then persons inquiring into the matter, but there is nothing to show that.
Let us first see your
yes,
first termination.
Page 20 is the first termination order. Whereas so and so, who has absented himself from leave overstayed, leave granted to him, deserted the unit with effect from 20th of October 1993 and is still absent. After 30 days of his absence, a court of inquiry under section 106 of Army Act 1950 was convened to investigate the circumstances in which the above named individual became absent, and the said court of inquiry declared number so and so to be deemed to be a deserter. That an apprehension rule was also issued in respect of number so and so to the district magistrate superintendent of police in the district to which the said individual belongs to apprehend him, but till date he could not be apprehended. He was surrendered to any army, Assam Rifle authorities, and is still absent. Now, this does not take into account the fact that I had gone there, and in the year 1996, they had asked me to come back with the court documents. They say I have not even reported back at any point of time. A total period of 5 years has elapsed since his absence. Therefore, I take into consideration the entire circumstance of the case. I am of the considered opinion that further retention of so and so is not warranted. I, therefore, by virtue of power vested upon me under section 4A, dismiss with effect from 20th of October 1993. My settled position of law, my lord, a retrospective termination can be effected. The period intervening for the absence can be treated as diasnon, that is a separate issue. But the termination cannot be retrospective, is settled position in law, my lord. It's Supreme Court judgment. Now, after this, my lord, what happened is, I went back to them saying that I was asked to come back with papers of my innocence or of my acquittal. I could not come back. Please help me out. At page 21, they say, you did not come back to the office on time. Orders for your dismissal have been passed. And they go and talk to the DGAR. My unit says so. That is at page 21. Original at page 22. In reference to application dated November so and so, you are informed that you did not come to this office because after completing official formality, we have sent it to Director at Shillong, and whatever amount you will get through Director General so and so. If you want to make any communication, you can do so with Director General Assam.
You are reading page?
I was reading page 21, my lord. Okay. So they tell me you go back to the Director General. Now here what I do is, the petitioner goes and files a writ petition at Allahabad before the Honorable High Court of Judicature, Allahabad. That is at page 23. Lack of territorial jurisdiction. It is dismissed. Now this dismissal comes on 15th of September 2006. Lordship will find down below on the order. Number of matters remained thus. If Lordship has page 24, another order of termination now comes up.
Yes.
Whereas number so and so, who has overstayed leave granted to him with effect from 20th 20th October 1993 and is still absent. After expiry of 30 days of his absence, a court of inquiry under section so-and-so was convened to investigate in the circumstances in which the above individual became absent, and the said court of inquiry declared so-and-so to deemed to be a deserter. The apprehension roll number so-and-so was also issued in respect of so-and-so to the district magistrate superintendent of police to the district in which the said individual belongs apprehending.
Why this why this second termination?
There is no explanation. I could not find an explanation, but it is there.
The
find
the respondent filed an affidavit.
Affidavit, yes, madam.
And do they explain there why this second why basically made them to pass the second order of termination? Is there any explanation there?
Yes, Lordship. I'll just read out that paragraph which refers to my paragraph 15.
Is there any explanation to that? Did you see any explanation?
However, it was noticed that later on that the power provision of section 4A endorsed that discharge order dated so-and-so was wrong, and the correct provision was section 4.1.
But that is for this thing, clerical, kind of clerical.
They
4A,
say
4.1.
4A, 4.1 is what they explain in the affidavit in opposition.
But then you see, like so far as your termination, it remains effective from the same date, 20th October.
20th October 1993. Now this backdated is something. Then, my lord, what happens is at page 25, the third termination order. This honorable court had, my lord, in one of the matters decided that the commandant would not be the proper authority to dismiss or terminate services in such manner. Therefore, my lord, perhaps this page 25 comes up, signed by the DIG now.
So earlier this termination was issued by wrong authority.
By the commandant. So the authority was wrong. So
he was below the appointing authority. His rank was.
The commandant was actually the appointing authority is otherwise the commandant, but in such kind of terminations under section 4A, this honorable court has held that it has to be the DIG. So therefore now, reciting the same things, this order comes.
They corrected it.
Now they give it back.
Otherwise it remains.
It remains.
Same.
So therefore, my lord.
So there is, you see, like in reality there is no three termination order, though there may be three orders issued, but then
Yes.
termination remains to be same.
The termination remains to be same. It remains with effect from 20th of October 1993. But there
the grounds of termination, everything remains.
Everything remains the same. So these.
Only it is only the correction of those technical.
So therefore, what I was trying to submit is what has now been brought into that the termination was in this manner. These were the reasons. Nothing comes out here. It is only because I was declared a deserter. I did not report back on time. They sent an apprehension rule. 5 years had elapsed, and I was terminated. None of the other factors which are now placed before this honorable court were factors under consideration while passing the orders of termination in the year 2011. Now, my lord, when I again approached the Honorable High Court at Allahabad, and at that point of time, the Honorable High Court said that there is a representation pending.
The Allahabad High Court said that not territorial jurisdiction.
That was for the first termination order. Now I had two other termination orders and one prayer for consideration of my pension and other dues which would come on my termination.
Yes. So, but then once it is outside the territorial jurisdiction, what is the question of approaching that court?
Wisdom of the petitioner at that point of time.
But then was it not something that is when they
have no territorial jurisdiction
was approach the same court?
Yes.
And you disclose that thing before the same court. What is the order passed in the second round of litigation?
Page 27.
They entertained your application.
They entertained an application to the extent that there was a representation which was pending that can be disposed of.
They entertained in whatever way there is a
to that extent, and
the first order, which said that no territorial jurisdiction.
My lord. That. But
that is, we do not know. Anyway.
So now in this, my lord, in this petition, the order is at page 27.
Yes.
Heard Mr. So-and-so, written petition has been filed for mandamus directing deputy so-and-so to pay entire pay and terminal dues of the petitioner. It has been stated that the petitioner was appointed as rifleman on permanent basis. However, he was terminated from service by order date 29/7/03. Termination was from retrospective effect 29 to 1994. However, during service period, certain deposit of petitioner were not paid to him. The petitioner has made representation in this respect, which is pending. The petition is disposed of directing the Deputy Inspector General of Police to decide the representation of the petitioner by reason or within a period of 2 months from the date of production of the certified copy of this order. Petitioner is given liberty to file a fresh representation along with other relevant papers and a certified copy of the order before respondent number 3 within a period of 2 weeks.
This order was passed on 20/12/2017.
17, yes.
Much after your final termination order.
Yes.
You did not challenge your termination before the authority there.
In this writ petition, we did not, perhaps. That is not what
You have
reflects.
enclosed a copy of the writ petition.
Writ petition I could not obtain at that particular point of time. I have got a certified copy of the writ petition here, my lord, which was filed the second time in the. It's a certified copy, my lord, which I have obtained. And here the prayers actually
Now,
were.
sir, supposing did you make a prayer there for interference with your termination?
No.
There is no prayer.
No, the prayers are
Now,
only for pension.
Once you omit to make it,
My lord.
what will be the consecution of that?
The termination stands. The termination stands, my lord.
Can you make this prayer for
I have
this
not.
thing?
I have not. I am not asking for a setting aside of the termination part.
Now, second part is that once you go
my lord,
and invoke the jurisdiction of the some other court,
yes,
you procure some order. Can you subsequently decide and change the jurisdiction?
my lord, the prayers there were that was entertained or was disposed of was to the extent that my representation needs to be disposed of.
This connection with one service, with one individual service.
Yes, ma'am.
Benefit concerning one individual.
Yes.
Some part you obtain from there, some part you obtain from here. Is it permissible in law?
My lord,
this court will not entertain, you see, this petition. Once you have surrendered to the other high court, you will go and approach that.
My lord, the orders which are now under challenge, which has denied me the pension, has been passed by authorities who are under the jurisdiction of this honorable court. And my lord, if that approach was wrong, my approaching them again would not, two wrongs would not make a right.
See, your approach, we do not know. See, there is something you just say us that, see, like for the release of service benefit concerning one individual, for certain part you have the liberty to approach one high court, and for other part you have the liberty to approach another high court. You just show us some way.
If my lord, if the situation was such where we could say that the Allahabad High Court was, we did not have the territorial jurisdiction, that was one part, my lord, which had to be addressed at that point of time.
See, that first part goes, because thereafter also you again approach the Allahabad High Court.
No, I'm talking about the second order, my lord. I'm not on the first order. The territorial jurisdiction was not there, is settled, my lord. Even to my understanding, my lord, Allahabad would never had the territorial jurisdiction so far as the service conditions of the petitioner was concerned. But my lord, there are orders of the Honorable Supreme Court, just for the I try to recollect, my lord, where it says that once the matter relates to pensionary benefits or rejection of a particular application made, two counts. The High Court where the orders are received in service matters may have the territorial jurisdiction.
Your pensionary benefit.
And on another hand, my lord, I would also like to
just a minute. Is your pensionary benefit, is it not dependent upon the interference?
No. It would not be. It would not be, my lord.
So even, do you want to say that even if your termination is upheld, you are entitled to pension?
I would be entitled for a consideration for a compassionate allowance pension. That is what I'm trying to say. Under provisions of CCS 41, CCS pension 41, and this has been held by this honorable court.
Have you approached the department for that?
Yes, and that was
what is their reaction to that?
That is under challenge in this petition.
What did they say?
They said that 24 takes away all your past service, and therefore we cannot go to consider any sort of pension for you. Whereas 41 says that whenever there is a termination by dismissal or removal, then the authority is bound to take into consideration the compassionate allowance given on the nature of the offence on which you are being terminated. And that has been upheld by the Supreme Court, not only it was laid down sometime in the year 2014, and it has been upheld even in the year 2023, that the consideration has to be there.
Now, this Allahabad High Court had given you the liberty to approach the Deputy Inspector General Assam Rifles for deciding the representation.
Yes.
Now you are challenging the decision before this court.
Yes.
Can you challenge it there?
Liberty
was given by one high court. Why it should be challenged here?
Because the orders which have been passed by the authority which has now passed the orders are within the territorial jurisdiction of this honorable court.
Has been passed in pursuance of the order of the Allahabad. He did not pass this order suo motu in exercise of his power.
In my humble understanding,
This
it
court
is
has-
not as if only one court would have the jurisdiction to try a particular cause of action. It is not that matter. In my humble understanding, what I understand is two courts, depending on the cause of action, who can and may have the territorial jurisdiction to decide a particular matter.
See, what leads to a cause of action, that is what is to be seen. What is the scenario behind the cause of action? You obtain a certain code, you procure some order. On the basis of that order, or that basically order compels certain official to pass certain kind of order. Now you are again aggrieved by the outcome of that order.
True.
Now you approach a different high court. Can it be? It is. I think this is
In my-
something.
in
this
my-
will cause a serious. You see, it's a mass. You see, like, can it be? Can you go on approaching any high court like this?
In my humble submission, there will be two factors which can be taken into consideration by this honorable court. One, wherever a part of cause of action arises, that court would have the territorial jurisdiction to look into the issue, number one. And number two, once I have got 2 or 3 forums where I can approach, 2 or 3 courts, if they have the territorial jurisdiction to entertain part of cause of the action, which the entire issue then has to be decided. Even if a part of cause of action arises, the entire issue is then to be decided by that honorable court. Now, if that is so, it would also be what we call, my lord, a forma convenience.
Had there been non-compliance of this order, where you would approach for contempt of court?
Why is the Allahabad High Court? Because it was an order passed by that court.
In that case, you will not say that cause of action is arising.
Cause of action for the contempt proceedings would only be the orders passed by the Honorable High Court of Jurisdiction at Allahabad, my lord. It could not be, and the cause of action would not be, they are not passing an order, but they are disrespecting the orders of the Honorable High Court of Allahabad. And therefore, it would only lie in Allahabad. But here is a case, my lord, where part of cause of action, a major part of the cause of action, my termination,
do you have any decision to show that?
Then Lordship would perhaps give me some time.
Honestly,
I understand, my lord.
Mr. Mojumdar, not take it otherwise. This court is not very much convinced about it, because this court is still under belief that the respondent number 3 or the Deputy Inspector of General decided a representation on the basis of an order passed by the Allahabad. Now, if you have any grievance with regard to that, you have to approach the Allahabad. If you find that what this court, the observation of the court at this moment, if it is wrong, just give us something there.
Then I will. This is something I was not
This
prepared
is something,
with.
you see, like basically the jurisdiction is one thing, right to the root of the proceeding.
I understand.
The
Then
second question you have to satisfy the court is that a writ petition filed after your termination, wherein you do not challenge your termination, can it be raised at present here?
my lord, I am not challenging my termination as of date also.
No, but then if your service benefit is dependent upon the
It is
validity of your termination.
The Honorable Supreme Court says a very valid termination order on grounds of whatever, on grounds of incorrigibility, whatever, even if the order of termination is upheld, the incumbent who was in service would still be entitled to all considerations under CCS 41. There is no escape from that for the department. That has to be done, and that was upheld in 2023 for Lordship's convenience, my lord, the 2014 judgment, which was almost on the similar facts, where he was dismissed on the ground of.
This jurisdiction part.
I'll then Lordship would like to give me some time. This is something which has come up.
But this is a thing. This becomes quite interesting for you. Say, like, even
I
the
understand.
court is also interested to know what could be.
I'll do my best to find out, my lord. Lordship, give me some
Dr.
time.
Mojiga, anything ready with you, so far as this is concerned? Because his entire cause of action arises on the basis of a
Order of the Allahabad
judicial order passed by a different Allahabad. Now, if he is not satisfied by the outcome of what basically has been initiated by him, can he approach this High Court? Is it not his bounded duty to go and approach the same High Court by which his order was passed?
My lord, in fact, by a coordinate bench, Justice, thank you. Just last week or 10 days back, in that matter, what happened, my lord, the petitioner approached Agartala High Court Agartala High Court similar directed to dispose of representation, to consider the matter. Second round he came before this honorable court. Then I raised the question of territorial jurisdiction that he should approach. Of course, the facts were slightly different. That order has been passed.
Order has been passed.
I have the copy.
This saying that
this court will not entertain. He has to go.
Do you have a copy of this order?
So helpful.
I'll place it now.
Yes. Okay, it's on the because Mr. Majumdar also will need some time to prepare. Now, say supposing here, see, the fact is that he first approaches Allahabad High Court. The High Court there declines, saying that see, we do not have territorial jurisdiction. Now, in spite of that, he again approaches that court. And whatever the reason, the court entertains. Now, knowing very well that the cause of action which was there at the time when the first writ petition was filed was outside the jurisdiction of that High Court, he approached that High Court and he makes that High Court to pass some order. He somehow, manages some order. Is it not that, a person goes and, of course, we do not know, the question of territorial jurisdiction, no amount of admission can confer that. This court is very much aware of the fact. But then once he himself invokes the jurisdiction of a court, which
and obtains an order.
What stand he will have now? Whether Allahabad High Court will have jurisdiction or not jurisdiction. If he says that it will not have a jurisdiction, so far as the present grievance is concerned, if he says that the Allahabad High Court has jurisdiction, then this court will definitely tell him go and approach that court. But if you say this court has jurisdiction, even in spite of the fact that if you find that this court also will have jurisdiction, this court will definitely direct you there, saying that you have already approached. See, you may have the opportunity of availing jurisdiction of
two
different courts. True. Once you have decided to invoke jurisdiction of one court, it would be proper to direct you to that court again. Because you have decided.
I follow.
So this court will definitely refuse to exercise jurisdiction. This is one aspect, and if you want to say that that should not be or rather it is not a sound principle to do that, then you have to show us something. And Dr. Mojika, that order.
I'm placing no.
That would help me.
And it be something like that. Say supposing now he has some other grievances, we dispose of this matter, we remand it back. Say for say, if it happens. And then after remand, certain order is passed by your authority again, and he is not satisfied, he approaches Allahabad High Court. Will it be possible? Will it be allowed in that?
That is one aspect.
Propriety will require that he sticks to the.
We do not know. This court is getting too much. Don't leave it to the thing on that. But then the court must be sure before it exercises jurisdiction.
Lordship will give me some time, my lord. I will try to satisfy it. If I find anything that I do not have a ground, my lord, I will also.
The High Council appearing for the parties at some length. From the materials on record, it appears that the petitioner earlier had approached the Allahabad High Court by filing a civil miscellaneous writ petition number 2976 of 2006. Which however was not entertained for want of territorial jurisdiction. Which was not entertained by order dated
15/9/2006
for want of territorial jurisdiction. Stop. In spite of the above, the petitioner and again approved the Allahabad High Court by filing a writ petition number, writ petition A number. It is numbered like that way, Mr.
At that point of time, it was numbered like that.
Writ, you just see from page 27, huh? It's number 613883017. Just see what are they can and the High Court therein was pleased to entertain the said writ petition and pass some order directing the Deputy Inspector General of Assam Rifles to decide the representation filed by the petitioner by a reasoned order within a specified period of time. Stop. The writ petitioner at present has approved this court on being aggrieved by the decision of the Deputy Inspector General of Assam Rifles, which was taken as per the direction dated 20/12/2017 of the Allahabad High Court. Paragraph. In the backdrop of the above factual aspect of the matter, a question arises as to whether the petitioner has the liberty to approach to invoke, the jurisdiction of different high courts. In relation to cause of action arising out from the same subject matter. Stop. The learned counsel for the petitioner seeks grant of some time to clarify this aspect of the matter. Dr. Mojiga, that decision of the coordinate bench, it is more or less on the same.
That was a contract matter, my lord.
But then the thing is that for the same cause of action, once a party, I mean like the one party approves first, subsequently, for matters connected with the same cause of action, approves. This coordinate bench has heard that this. It seems to be that way. I do not know, Mr. Mujumdar, whether you have come across the decision.
No, I have not come to the decision, but I'll go through it, my lord.
Because this is one thing.
If I get the
there's one thing is that you will not have the liberty to approach any high court you want. At least some should be there. Some yardstick should be there.
It could be so that, my lord, if the petitioner did not get a relief in the Agartala High Court and he wanted some other sort of a relief on the same cause of action, a modification of the order or something, if he had approached this court and this court perhaps said that no, you approached
here
the
one thing is that he approved the Allahabad High Court first.
Yes, yes.
And then the Allahabad High Court
Yes,
declined to interfere, saying that no.
We don't have the territorial jurisdiction.
But even in spite of that, he approves the High Court. Now this is what you see, like, though probably you see, like,
he was the client, my lord, is a person who's not even class 8 pass at that point of time. Advices come from people near about, whatever they get, whatever they do, it's a matter of
you see, like, this court was on the other side for quite for about 3 decades, so that is understandable. But then once you are here, you have to decide in accordance with it. Yes, what is the last line? You stop accordingly. This matter. After?
It's within 2 weeks, my lord.
After 2 weeks. That will be all right, Dr. Mujib. And you see, this appears to be
more or less identical matter was that, my lord. There also Agartala High Court said that the disposal of representation.
That is what, see, like, what this court wants to see, like, if the cause of action, if they are interlinked or interconnected, for certain purposes, whether you can approach one High Court, and for certain other purposes, you approach another High Court. Whether that liberty will be there with the litigant or not. It should not be something like that, that today he likes the Madras High Court, he goes and approves Madras High Court. And for something else, he finds that Meghalaya High Court is proper, he comes and approves Meghalaya. And that too, knowing very well that Allahabad High Court has no jurisdiction. Now what happens? A person, after having knowledge that a court has no jurisdiction, obtains some sort of order from there, can he subsequently come and seek implementation of that order, or say that something wrong has been done in pursuance to the function discharged by the officials?
My lord, in fact, the situation will be even bad for the petitioner, my lord, because there are some Supreme Court decisions that in case of termination of service or for payment of retirement benefit, he can approach where he resides, taking the clue from the Administrative Tribunal Act, my lord. Under CAT, there is a provision, my lord, the petitioner where he is residing or where he is posted, he can file the case.
Posted is one part, my lord. Posted is one part. Residence, there is only 1 or 2 judgments that I have found which say that when the orders dismissing the appeal or the rejection of the revision filed after the termination, and if there was a prayer for pension and other factors which will be payable at that particular place of residence, it is then he can invoke the jurisdiction of that particular. It was a person from Bihar who was dismissed from Mumbai Port Trust, and Honorable Justice Ranjan Gogoi's judgment is there saying that it could be done in Bihar also, because the pensionary benefits would lie there. And there are 2 or 3 judgments where the wives of deceased employees or terminated employees had moved petition, mothers had moved petition for this thing. That was there.
Now, see,
in
your
those conditions.
prayer before Allahabad High Court
I'm sorry.
was definitely you prayed for some relief, isn't it?
Yes, yes, for
But the
pensionary
Allahabad
benefits.
High Court has not given you the same relief. Instead, directed you to file a representation. Now, the relief which was prayed before the Allahabad High Court, okay, though was not granted, but the order was passed you to approach the thing. The same relief. Now, if it is refused by the department, can you come for?
That is what I will try to, my lord, find out if there is
You
some,
have
if
to
there
be
is some
specific on
material.
these things, because you see the relief which you are seeking from this court.
My lord.
Well, initially, you made a prayer for the same relief before the Allahabad High Court.
My lord, few lines. This is one teacher. Para 6, my lord. Directly, the lordship can see.
Yes.
The undisputed fact that is patent on the face of the records and materials as placed, so that the NIT had been floated for a project which was to be executed in Tripura, and as per the objections that have been reproduced at para 3 above from the side of the respondent, the main cause of action can be clearly seen to have arisen in Tripura. The most telling fact, however, has that tilts the case in favor of the respondents is that the writ petitioner had approached the High Court of Tripura by way of WPC number so and so, which was disposed of by order dated so and so, by allowing the petitioner to approach the respondents for refund of the performance guarantee. The representation as allowed by the High Court of Tripura being rejected by the respondent by the impugn order dated so and so, the petitioner, instead of seeking remedy before the High Court of Tripura, as resorted to by the earlier writ petition on a continuing cause of action, has instead approached this court seeking relief, which clearly smacks of formality.
Yes, the last few lines. The representation is allowed by the High Court of Tripura.
Here, my lord, what is explicit is the Honorable High Court of Tripura originally had the territorial jurisdiction, and this was a court which did not have
the last line. The first part because of these paragraphs definitely doesn't go against you.
They go against.
But then only the last thing. The representation is allowed by the High Court of Tripura, being rejected by the respondents by its order so and so. The petitioner instead of seeking. So here also is the representation which is allowed by the.
No, here.
That is what.
I'll try to go through.
Take your time.
Important phrase used, my lord, is a continuing cause of action.
See, the
more important is the formatting part.
The decision of a coordinate bench is binding on subsequent.
It has to be.
So that also bearing.
If I can, if all the facts remain similar, that I will. I'll try to bring in whatever I can, madam.
No, you are making this thing tougher for this court.
I understand, madam. I stand for the client, madam.
Instead of making it a like a straightforward case of service thing, now we have to go into travel into many other things. Shall we retain it? Yes. Anyway, interesting.
I'm obliged.
Item number 16.
Yes, Mr. Shulai.
Lordship, this is also a question for settlement.
Yes, Mr. Sonar.
May please. My lord, before I start, my lord, last time it was pointed out, my lord, there were 11 accused in the trial court. The quashing is filed by 9. So 9 accused. So what happened to the 2 accused person? So I could not reply that day. So when I applied for a certified copy, my lord, I found that 2 accused persons were expired, my lord.
So is it not required that it should be mentioned somewhere? It is.
May it please your lordship.
Yes.
Lordship, kindly come to page 68 of the application. I'm taking your lordship straight away to
page 68.
Page 68, your lordship. Yes. Lordship, kindly. These are the name of the accused person, your lordship. Lordship.
Just a minute. Sure. This court is yet to come to page 68. Yes.
Lordship, kindly see serial number 4.
Yes.
It appears, your lordship, there is an order passed by the London Session Court on 26, 2017 that yes, he died, they produced their certificate. But so far, serial number 11, Jeriwell Manku, your lordship, I don't see anything in the order, your lordship.
No, it's the last part of the order.
What is the order?
This is a certified copy. Can I give to the court?
Where is that last page? Huh?
Oh.
In the second page, your lordship, paragraph 2, it is mentioned regarding the accused number 4.
Lordship, yes.
And last part of the order, my lord, para 11.
Yes.
This is regarding the accused number 11. So these are the 2 accused.
Yes. Okay. Then lordship.
So then we can proceed.
Yes.
Lordship, yes, the matter can be closed, your lordship. So far the state is concerned, lordship, the state will not stand on the way of the compromise between the parties.
On which date, which then did this thing? What was the order passed by the court?
Trial court, my lord.
So far as the two disease accused are concerned.
So my lord, no orders passed, my lord. We have approached. I have said in paragraph.
Stood awaited.
Kindly page 7, my lord. I made a statement here that.
Just a minute. Let us come first to the order passed by the trial court, which you have placed before the court just now.
Oh yes.
Now you pointed out para.
The para.
Lordship, first comes to the order dated 20th 6 17, lordship.
Yes.
It has not been paging is not done, your lordship, but order dated 20th 6 2017.
Para 2.
Lordship, kindly come to para 2.
Yes.
That is Kiri Masenting.
Yes.
That is accused number 4. Then lordship, kindly come to lordship. There is a paging 42.
Just a minute. Before that,
lordship,
calm down. What is the order of these things? Prayer for defense counsel is considered.
Considered.
Refix for so and so. What is meant by considered?
Lordship, that means consideration of charge, lordship. Lordship will kindly come to 17/1/2018.
No, but then so far as this deceased accused is concerned,
lordship,
any order passed saying that the trial stands awaited.
Yes, your lordship. The charges against the accused Shri Kiring stand dropped as abated.
Yes,
lordship, it is there. Yes. Then I'm taking your lordship to page 43 at para 11. So far, accused number 11 is concerned.
Yes.
Lordship, kindly see at 11.
Yes.
The defense counsel has submitted a death certificate of the accused.
You have given us the original copy of the order.
Yes, madam.
Why original? You do not have a Xerox copy. Give us. You would not like to make any.
No, because I met.
Why it is not legible?
Huh? Give me that copy. Yes, I'll give you this one. I'll make some marking there because
Of page 43, Your Lordship,
Last-
para 11. The defense counsel has submitted a death certificate of the accused Jemuel Mangu.
One second.
Lord.
Nathan is there. You are alone. Yes.
Mangu.
It's all right. It's all right.
Lordship. The
Now-
case stand abated against the accused Jemuel Mangu, Your Lordship. So, Your Lordship, since they have compromised, Your Lordship, as I have submitted, state would not stand on the way.
Yes, Mr. Sunay, just give us the factual aspects of the matter.
I'm just pointing a lot.
Oh, Mr. Sunar will give us the factual
Lordship,
aspects.
yes.
It's not Mr. Shula, you said Mr. Sunar.
Well, there is a title suit, my lord.
No, just tell us what is the dispute from which this
Dispute
FIR had arisen and then.
my lord, page 12 is the order. The title suit, there was a title suit between the complainant and the accused person. So, on 22/6/2016, they made a settlement.
Page
12, my lord. Annexure.
Yes.
So,
who filed this thing? Who filed this complaint?
page 12, my lord, this is an order, my lord.
Just a minute. Page. What is the FIR?
FIR. FIR is my lord, page.
You are seeking quashing of a criminal case, isn't it?
Yes, my lord.
So this has started
No, I wanted to submit that title suit was pending. That is also settled.
We'll come to titles subsequently. Let us just gather about the criminal case.
Criminal case. My lord, the FIR is page 20.
Yes.
Type copy is page 20.
Yes.
So may I read?
This is Rangbasnong of
Rangbasnong of yes. Umdatli village.
Yes. You are representing Restaurant number 2.
Number 2.
And you have no objection to. Are you objecting to the prayer made in this petition?
Question.
You are supporting the case of the petition.
Because there's compromise. We have compromise.
Whatever it is, you are supporting the case. It means saying that there is a compromise.
This is the FIR, my lord.
Okay. Now, on the basis of the.
Alert.
On the basis of this.
Under this.
They think that the case was registered.
Registered.
What is the case number?
Case number is Umiam PS case number
page 73.
You can take another.
Lordship, kindly come to page 73 of the application. It has been mentioned in that compromise agreement. That is Umiam PS case number corresponding to session case number 28.
What is the law in this regard? What is the law in this regard to this thing?
Offence, my lord.
Yanching.
Only 440.
No. What is the law with regard to the quashing of criminal proceeding on the basis of the agreement? What is the decision of this apex court?
My lord, that is when the parties settle, my lord, the matter can
what
be.
are these relevant decisions? Where are the decisions?
Decision right now. It's not there, my lord.
Give us, we need to reflect it here.
This is under 482.
We understand that, but we know that there is a thing, but we want to see those decisions. You are not ready with those decisions?
Yes, but today.
Very surprising. It should have been there.
Yes, my lord. Decisions are there, but
we will have it. once when you can produce decisions?
Tuesday, my lord.
Tuesday, what? 23rd?
22nd, I think.
Yes.
Well, it will after a week.
After a week.
After a week, my lord.
Mr. Shuna,
My lord,
do
my
not
lord,
take anything
my
as
lord, my
granted.
lord, my lord. My lord, there is a decision.
Probably
also
this court, it is not that the court doesn't know the affection, but then there may be a requirement of referring this judgment.
My lord. Apology, my lord.
And when you have law in your favor, why not praise it?
Well, my lord, only that part may my lord, that regarding the two accused person, my lord, that may be recorded.
Yes, Mr. Nagla, we'll have it after a week. We'll dispose it of in the things. There is will not be very, like complicated matters. Since
Yes.
Mr. Shulai has no objection.
Yes.
So only thing is that we need to refer those decisions. Please come with those decisions. Just as requested by the learned counsel for the petition, and this is matter after a week.
After a week. Apply your law.
Apology.